Hey everyone, Harry here to talk about another round of review on appeal that's been authorized by Scott McAfee in the Fulton County case. And if that case didn't already seem off the tracks in terms of having any prospect of taking place actually occurring before the election, this one would, I think, pretty clearly dislodge it. Okay, so recall we have the motion to disqualify Fani Willis based on not very much in terms of what they needed to show, a financial conflict of interest. Nevertheless, McAfee convenes an evidentiary hearing and a three-ring circus ensues with testimony from Wade and Willis and others and all kinds of extraneous issues in particular about when their affair started that really did not go to the one thing that the defense would have needed to show to get her disqualified, a financial conflict of interest, and in other words, some kind of dual loyalties, so that they were on the one hand looking to prosecute the case fairly and aggressively, but on the other, for some financial reason, had conflicted goals. The idea that could be the case because maybe Wade was buying her flowers or paying for airline tickets in cash never to me had any purchase. And indeed, McAfee came to say you can't show it there. But in the process, some really rough body blows on his part, basically calling into question Wade and Willis's credibility and that of another witness, talking about an odor of mendacity in the case, etc. And then not because of financial conflict, but because of the appearance of a conflict, sort of amorphous. He ordered the entire office, including Willis, to step aside or Wade to step aside, which was, of course, no real choice at all, and Wade stepped aside. That's where we started as of a couple days ago. And then the nine defendants promptly appealed his motion, or sought to, saying, you didn't go far enough. You should have disqualified Willis and the whole office. And they're adding dismiss the whole case. And that's a slew of defendants. The person, Mike Roman, who bought the original motion, but Trump, Mark Meadows, and others. So to do that in Georgia, to go on appeal now in a fashion when the rest of the case is still ongoing, you first seek permission from the trial judge, McAfee, a certificate of immediate review. And he gave it here. Again, to me, it's yet another in what's been, I've been impressed with him overall, but he's been quite indulgent about this claim. And I really don't see the prospect that the Court of Appeals would find a financial conflict of interest. Nevertheless, he said, have at it, you nine, and go to the Court of Appeal. So they're doing that now. Now the Court of Appeal decides whether it will take the case. You have to have it on both sides. And that process takes 45 days for them, so that at the end of it, they could say, no, we're not going to hear the case, essentially affirming what McAfee did. I would think, I don't see them reversing McAfee. There's maybe a prospect they take the case and affirm, or they simply don't take the case. But at that point, guess what? The losing party, I expect that to be Trump and company, can take it to the Georgia Supreme Court. And the Georgia Supreme Court can decide whether to hear it. So even if it goes quickly through each of those levels, we're talking about a couple months. Now, McAfee importantly said, I'm not suspending the case in the meantime. We're going forward with the other motions that we're hearing, including the pretrial questions that would, in theory, set up the prospect of actually convening a jury going to trial. But it seems inevitable to me that this kind of hovers over the case and in practical effect imposes a certain amount of friction that just slows things down. And of course, if for any reason either the Court of Appeal or the Supreme Court hears the issue, that really slams on the brakes even more. given where we were, remember, as of before this motion, which was kind of a shot in the dark, arose, that the case was proceeding in pretty streamlined fashion under the stewardship of McAfee. Now, of course, it always was something of a long shot because it's a RICO case. So it's very sprawling, multiple defendants. Everything takes forever. And every case against any defendant involves all the evidence against all defendants. That's just the way that that RICO works. So, and then in addition, for reasons I can't quite figure out, we're told, and Fani Willis has told the court, that jury selection is expected to take at least 3 months. So if you do the calculation, it was already remote. But then the whole debacle ensued involving the motion to dismiss. And that just slammed the brakes on I think it's been almost, more than a month that they've been sifting through this. And now, even though McAfee says we're going to continue to go forward, it just strikes me when you do the math and you put in the factor that there are 9 defendants to cross-examine or file motions or do everything they do, and then if we're anywhere near this actual 3 months or more of jury selection. So this, to me, has gone along with Mar-a-Lago, where Judge Cannon seems never to see a Trump motion she doesn't like or an opportunity for delay she doesn't grant. They've now gone to the sort of bottom of the pile in terms of prospects for actually a jury trials occurring before the election so that the American people would be able to process that information in deciding whether they want to vote for Donald Trump for president. So the saga, the sort of melodrama and saga of Fani Willis and her relationship with which we can stipulate, a standing stipulation, as in fact McAfee says in his order, terrible lapse of judgment, shouldn't have happened, etc. But that's a very different question from whether the proper remedy is to somehow disqualify her from prosecuting the case. Anyway, and now new round to that, and the prospect for the certainty of over a month and the prospect for a fair bit longer, while the courts of appeals and potentially even the Court of Appeals and potentially even the Georgia Supreme Court get their own whack at this motion to disqualify and weigh in themselves. And I'll just say, I don't know the Georgia Court of Appeal. I don't know the Georgia Supreme Court, but I've come to learn a little about Georgia, and it is politically roiled. And there are a couple state commissions already looking into Willis, and it's just part and parcel of Georgia politics, which means in 2024, where Georgia is something of a swing state, national politics. So it's in the interest of the Republican Party to keep the focus on Fani Willis and her, ethical issues or personal issues. Jim Jordan in Washington is making a point of it, and it all augurs really poorly for the case itself actually coming to trial any time before the election. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.